Good morning or good afternoon in whatever time zone you might be. It's the 27th of February 2023, and it's 5 o'clock p.m. In Vienna, where I'm at the moment, and it's 11 a.m. in Washington, where my guest today is. It's my pleasure to introduce Professor Daniel J. Solove to you, who is the Eugene L. and Barbara A. Burnett Professor of Intellectual Property and Technology Law at the George Washington University Law School. And he also founded TeachPrivacy, a company providing privacy and data security training. And he's one of the world's really leading experts when it comes to privacy law, in particular because he wrote more than 10 books and more than 50 articles in the domain. The reason why I invited him, and Daniel was so kind to accept this invitation, are two articles that he recently wrote, and I think that both of them are of dramatic importance for the European debate. The first of them, this is the one that we will probably talk about in the first part of this conversation, is about the European European concept. It's going to be a little bit more than just European, the also European concept of sensitive data. And Daniel has a rather critical point of view on whether it makes any sense to regulate sensitive data separate from other personal data. And the second, perhaps for Europeans, even more relevant article, I don't know, both of them are very important, but that one might even be more important because this is perhaps even more fundamentally enshrined and written in stone in the European data protection law, is this one here on murky consent, an approach to the fictions of consent in privacy law. Both of these articles are freely available as preprints on SSRN, and the link to both texts is in the show notes below. Daniel, thank you so much for being here. It's really a privilege. I'm very excited about having you here. One of the reasons why I'm so excited is that, as you certainly know, there is an ongoing debate at the moment in Europe happening whether GDPR would need some kind of an update or whether there should be a fix of GDPR. And the European Commission has taken this point and it has announced that they are going to propose changes in the GDPR. However, as far as we know, those changes will only affect the cooperation between data protection authorities in Europe. So both of the topics you are dealing with, to the best of my knowledge, are not in scope of those suggestions. Would you think that GDPR needs an update, and where do you think that this update would most urgently be needed?
Well, I do think. Well, first of all, thank you so much for having me. I'm really thrilled to be here. I a couple things to start. One is I want to start by just saying I think the GDPR is truly an amazing law. I mean, it's a great accomplishment. It is a tremendous advancement in the law. It builds on I think the already great ideas in the directive. It's But it's still an early move in privacy law. We're still very young in the law. So I do think that the law needs to evolve. The GDPR is not the answer yet, but I do think it's an important step forward. But there are things in the GDPR that I think are that don't work very well, that are not going to really succeed. And that's the topic of a series of papers that I'm writing. Before the two that you mentioned, I'm writing. I wrote a piece that's almost going to be out. It'll be out in a month or two, called "The Limitations of Privacy Rights." And there I argue that the laws, including the GDPR and many other privacy laws, rely a little too heavily on individuals to assert rights under the laws as a way to regulate privacy. Now, certainly there are other ways that the laws govern privacy, but the privacy rights, I think, take too strong or bear too much weight and are doing too much work. They're important and should be a secondary player, but just too much weight. And that goes to a general theme in a lot of the work, which is that privacy is immensely complicated. There are so many companies and organizations that are gathering people's personal data, and they're using it in increasingly complex ways with algorithms that are incredibly hard for an individual to really understand and assess the risk of, the implications of their data being analyzed and then decisions made upon it with these algorithms. And then it just doesn't scale given the amount of organizations out there that are collecting data. I call this generally privacy self-management. The idea that we're going to give individuals control over their data, and that individuals are going to then be in the driver's seat and be able to manage their privacy. And overall, I think that while that goal is certainly a great ideal, it's not practical in practice, and certainly becoming harder and harder given the way that technology is developing, and it's going to be nearly impossible. I think it's impossible already, but it's even going to be more impossible as we go into machine learning and AI. It's just going to make it even more complex. And so with all that going on, I think that it's just not going to be feasible for laws to rely as heavily on privacy self-management as they are now. And so the larger project is trying to rethink the law to address and regulate privacy, relying less on self-management. And that's sort of the broader picture of where a lot of these papers are coming from, is how do we make the laws work with the technologies that are developing so rapidly.
Yeah, that's interesting. I mean, because one of the arguments that you are making in this first article about sensitive data is a very historical argument. You're going back to the 70s even, and to the first data protection laws in Europe, in Hessen and in Sweden, in this article. And in my view, this is already part of a lot of the explanations about where we stand at the moment. That at least from a European perspective, everything here needs to be understood from a historical perspective, and then in particular, for example, with the background of the German interpretation of data protection law and the German interpretation of the fundamental right to informational self-determination, as they call it, informationelle Selbstbestimmung in German, right to independently and individually decide on what's going to happen with your data, which was written into the German constitution literally by the German Constitutional Court in 1983. So exactly 40 years ago, when the IT landscape still looked very, very different from what we see today. However, this idea of informational self-determination then probably made it through the directive in 1995, and then finally still is quite clearly visible when you see the GDPR and the heavy impact the concept has on GDPR. So I think all this is related quite closely with each other. What the lawyers missed, however, is the fact that the IT infrastructure changed a little bit between 1970 and 2023. However, what the Germans did not do in 1983 was that they did not draw a distinction between sensitive and non-sensitive data. So the German Constitutional Court even made explicitly the argument that every data can become sensitive if it's put into a different context. So this is not German, this idea, this distinct, at least in my reading, is not German, this distinction between sensitive and non-sensitive data. And my hypothesis now for this debate would be that we have some kind of, two different approaches here. The first one is informational self-determination, very German. This idea of everything, not everything is equally risky, not German, cumulating in GDPR in a rather complicated way. And from GDPR now making its way all over in the world, because this is another very interesting point in your paper, in my reading at least, that you are arguing that GDPR now has an impact on how the debate is happening in other areas of the world, including the US. Am I drawing the picture correctly?
Yes, absolutely. A couple thoughts. One on the right to information self-determination.
Mhm,
The there's a I think early on, the idea that the individual should be in control of their information is one that I think is makes a lot of sense at the time it was created, because you really just did not have the kind of algorithms and the kind of complexity and the number of entities that had information that we do today. And so the idea that the individual should be in control is sort of it makes a lot of sense back then. I think the problem is that it's so complicated these days. I just don't think it's possible to really have meaningful control for the individual, even despite the fact that I think it's a great goal. What I think, though, that's important when we speak about control is that um, information should be under control. It doesn't mean that the individual uh, is necessarily the one controlling it, but it's very important that the way that the data is collected, the way it flows, the way it's used is under control.
mhm,
And I think that distinction is very important between, me having control versus the information being under control. And I certainly think the individual should have rights. I think the individual should have some degree of control. So I'm not about trying to take control away from people, but I think that in light of modern times, it's just too complicated for an individual. I think even an expert, I can't control effectively how my data is used and make decisions about privacy because I just don't know enough. Um, uh, and really I don't have time to find out what I need to know to make that risk assessment. So that's the problem. On sensitive data, I think that this is, I think, a well-meaning concept. It's an idea that recognizes, I think, rightly, that not all situations involving personal data are equal. That there are going to be instances that are higher risk than other instances of data collection and use. So we need to have different levels of protection. And so generally, I think that idea is great. But I think the mistake that gets introduced into the mix, which I think that gets to some extent, uh, and I agree with you. We have different ideas kind of pulling in the GDPR. It's not completely coherent because there are other instances that do focus a lot on use rather than on the nature of data.
mhm,
But to explain, sensitive data tries to use types of data as a proxy for what is high risk. That certain types of data are going to create greater risks of harm and should be more tightly regulated. And the GDPR identifies categories like health and race and ethnicity and uh, the political opinion and religious beliefs and trade union membership and others. Um, uh, and I think that sometimes these types of data could lead to greater harms, but sometimes not. Um, uh, and I think ultimately, though, it's not workable. And the reason it's not workable, and the reason why I think it's going to fail, is because in the modern data economy, inferences about sensitive data can readily be made from non-sensitive data. Now, the uh, European Court of Justice, or CJEU, has recognized that inferences about sensitive data count as sensitive data, even if those inferences are made from non-sensitive data. So, essentially, I think rightly so, that if you're going to recognize sensitive data and protect it adequately, you have to include inferences about it. Otherwise, it becomes meaningless. And I think that decision's right of the court. However, I think the implication is that all data is sensitive because with the algorithms that we have today, all sorts of inferences about sensitive data can be made from non-sensitive data, and it's practically impossible for us to figure out what non-sensitive data an inference couldn't be made about. So health, a very broad category. What could give rise to an inference about health? Well, pretty much everything I do, how many steps I take a day, what my exercise is, how my location can give away how I'm moving about, uh, what I'm eating, all sorts of aspects of my life can make inferences about my health. An example is the very famous case that happened in the United States many years ago involving Target. They wanted to advertise to women who were in the early stages of pregnancy before they started buying products for their babies. And they managed to be able to figure this out. And what they did was they actually looked at the kinds of things they were buying. And one of the things was they were buying unscented items. And so, that's, yeah, people might not have thought of that. And that's not sensitive. You buy, like what kind of, hand cream you buy suddenly gives rise to an inference about your health. And if that's the case, then essentially, I think, under the GDPR and as interpreted by the CJAU, all data is sensitive data. So, and that the category of personal data that's not sensitive data is the null set.
Yeah. Daniel, if I may, 3 questions on this. The first one is the following: if I were working for a European data protection authority, I would argue this is not a problem because the only consequence of this is that the layer of protection is increasing. Also, the processing of sensitive personal data is not automatically illegal. However, there's a difference between Article 6 and 9, and then if everything is becoming sensitive, why shouldn't we then protect everything according to Article 9? And the main difference between Article 6 and 9 is that Article 9 doesn't have the exception of legitimate interest as a legal basis for the processing. So there is no such thing like legitimate interest as a basis if you're processing sensitive data. And my answer as a DPA would be, well, this is perfectly fine because this is exactly what we want. We don't want the Googles, Amazons, and Facebooks of this world to collect everything, arguing that it's not sensitive on the basis of a legitimate interest. So this is not counterproductive, but on the opposite, it's a positive development of this tendency written by the Court of Justice of the European Union that everything is becoming sensitive. That would be my first question. The second one, that's perhaps even a more fundamental question, is wouldn't that argument also be true for the distinction between personal and non-personal data? And wouldn't it then be more of a consequence to argue we also should get rid of this distinction because everything can become also personal data, and then it's not even that important whether it's sensitive or non-sensitive, but everything is suddenly under scope of GDPR then or any other data protection law. And the third question, if I may, would be, isn't the core of your argument that this distinction between sensitive and non-sensitive is in a way random or philosophical because it explains something about the legislator more than about the person, the data subject, and their interest, right? It's more about what a society, what a legislative system believes in most fundamentally, and that's very different. And wouldn't we then better discuss about whether this list is appropriate instead of discussing whether this higher level of protection is appropriate?
Wow, these are great questions. Quite a lot of work ahead of me to answer all this, but they're wonderful questions. So the first question you asked involves, well, what's the harm of treating all data as sensitive data? And maybe it's not so bad. I think there are some difficulties with it. That the I think the legitimate interest exception is a little bit broad. I think it can be abused, but I do think what I like about it is it's one of the lawful bases that allows for an analysis of risk. It actually does look at you can use the data, but you can't create risks to rights and freedoms. That I think is really a valuable thing to do. If you don't have that there, then it all falls on consent. I mean, the main uses of the data, it's in practical purposes that most companies are going to use it either under legitimate purposes or consent. And so if it all falls on consent, that puts a lot of weight on consent. And as I said in the other paper, I think consent is actually pretty problematic in a lot of ways. And so I feel that if we shift too much to consent, we're going to have some problems. I can talk about that a little later, but I'm not necessarily a fan of resting the entire edifice or so much weight on consent. I think it's going to really break. So I think that the legitimate interests serves a good function. I might be a little tighter on it or have more rigor to it, so it doesn't become a gigantic loophole. But I ultimately think it's actually looking in the right direction and asking the right questions. It does a risk analysis. So that's why I'm not too much of a fan of just saying let's just regulate it all that way and we're all going to live happily ever after. I don't think that way of the treatment of sensitive data in the GDPR is ultimately protective enough. So I would like to see more protections, but just a different way of protecting. So that's one. The question one. The second question is personal data. And you mentioned, well, aren't there problems with personal data and the scope of that? And I agree, there are some challenges there. I actually wrote several papers with Professor Paul Schwartz at Berkeley on personal data. I looked at in one paper we looked at the U.S. approach and actually in both papers we looked at both the U.S. approach, and U.S. approach is kind of all over the place and it's incoherent. And then we looked at the EU approach, which is personal data is identified or identifiable data. Problem is that it's so easy to identify personal data from combinations of data, so it becomes a really tricky thing. And other scholars have written about how almost all data is potentially identifiable. And we said that, yes, it's true that almost all data is potentially identifiable, but there are risks. And in a lot of cases, it's, practically not that readily identifiable. Certainly, if you take, in a lot of these studies, computer scientists who kind of get together and figure out, some clever way of identifying a certain piece of data, then yes, if someone's going to put that much energy to it, it might be able to be identified in some cases. But that doesn't mean it's likely. And that doesn't mean it's a high risk. And ultimately, the law, we can't get risk to zero. But we ultimately have to, you can't have all data be personal data. It's non-workable. Otherwise, you regulate the dictionary. You'd regulate, the population of, population of a city, or every statistic, everything, every fact becomes personal data. That would be just unworkable. So we have to come up with some boundary and some concept here. And I think the only way to do it is look at risk and say, in cases of kind of high or moderate risk, that's where we're going to call it personal data. But if there's a low risk of identification, we should just say it's not personal data. Not because we want to just totally dismiss the risk, because if the risk does materialize, certainly that would then put it into the category of personal data. And if the risk suddenly changes and becomes higher, we would rethink that. But we must do something, and we can't call everything with any even minuscule amount of risk as personal data, or else it becomes the privacy law regulates the universe. So that's sort of our approach to that. And we talk about how the law can move to this type of approach, and it's workable. And it also evolves over time. As things change, the what personal data is can evolve based on changing risk. So that's our answer there. But for sensitive data, I actually think, and this gets to your third question about aren't these categories arbitrary? And I completely agree. I think they're totally arbitrary. They are just what different legislatures think is sensitive. And, they sort of hit some intuitions, but drawing this distinction between sensitive and non-sensitive data has certain problematic effects. One is that it kind of devalues non-sensitive data. It basically says that this type of data is more important than this other type of data, and that's wrong. I also don't think that the sensitive data is more likely even to be riskier than non-sensitive data. And also, I think that the way that the categories are not readily, they don't have easy boundaries. So, just an example, philosophical beliefs. What is that? There's a whole big debate in philosophy about what is philosophy. Does philosophy include science? Because I am a pragmatist. I like John Dewey and William James, and these philosophers believe that the study of science, the study of sociology and science and other disciplines were not wholly distinct from philosophy. That philosophy wasn't just some kind of abstract thinking, but it involved thinking about the world and empirical research about the world and so on. So if that counts, so that would mean almost all of my views on science are sensitive data. My views on and really philosophy, isn't it just a worldview? So my entire life's worldview is is um, is is covered, and everything I read informs my life's philosophy. I teach law and literature. I believe that in my class it's very philosophical. I believe that there are a lot of philosophical ideas in literature, like some of my favorites, Kafka and Dostoevsky. So I would say that's philosophy, right? And uh, I don't know where the category of philosophy really ends, uh, but I think that everything that kind of informs my worldview would then give rise to inferences of my philosophy, right? The movies I watch, the books I read, my entire intellectual life. And you could say the same for religion. There's a lot of things that people do that are that will give rise to inferences about their religion. Things they eat, where they go at different times of the day, when they take off work, and so on and so forth. So we have that as well. Religion is a and is atheism religion? Does that count? And if it does, then all sorts of things could give rise to, a view of someone, being atheist or not. And then, we have the other categories. And so it's hard to say like where one begins and where another really ends. Health, I mean, just everything I might do in my life. And so I kind of say that like the data is kind of like a grand tapestry and it's all interconnected. And then what I think the harmful thing about saying, oh, well, this data gets special treatment versus other data is that it's not the data itself that really controls anything. It's not the right thing to look at. That's why my title of my paper is Data is What Data Does, because data, just imagine a piece of your home address. That doesn't seem very sensitive. And under the current regime, home address is generally not protected that much. Okay, that's just not as important as other things. It's not as important as, the fact that, I might like the philosopher Nietzsche. What if your home address, what if you're a domestic violence victim? What if you're, being stalked by somebody? What if you're, what if you've, you're doing something that's controversial where there's a death threat against you? Now your home address becomes a matter of life and death. And it becomes essential to, your well-being to keep that information private. So we would say that, for some people, home address is the most sensitive piece of information. And you can see that with a lot of pieces of information. It's not just home address. It's just one example. And I think that, to say, oh, no, it's the data. Well, it depends. Some sensitive data is not that sensitive. Is it, if a for the Pope, they're the religion of the Pope. Do we need to protect that? It's all dependent on context. It depends on how the information's used, and then what harms or risks are created from that use. Certainly, there are instances where the use of this information can be very harmful and create risks. But there are other times where that information might not be harmful and does not create risks. I don't think that these categories of sensitive data are a good proxy for risk, because I think it's too complicated and it doesn't really map on very well. And it leaves a lot of other data underprotected. So it's overprotecting information, it's underprotecting other information, and it's really neglecting what I think is the key inquiry that privacy laws must make, which is, what is the use of the data that will then determine, and we have to then think about what are the harms that can be created and what are the risks. And the regulation of that data and the protections should be addressed to the harm and the risks. So in some cases, that harm and risks might be much higher than what the sensitive data protections are currently in the GDPR. It's not enough. In other cases, it's overkill. It might be too much. But the law's protection should be focused on and built around addressing these harms and risks. And right now, I think it's the GDPR sometimes does this. And I see this concept is in the GDPR in certain parts where it does talk about risks, just like legitimate interests and in the data protection impact assessments. So there are parts of the GDPR that do look at this, but then there are parts that don't, like the sensitive data. And this might get to the fact that you're talking about these different ideas and concepts in the GDPR that are cobbled together, that are not necessarily fully congruent. But I think that concept, that when the GDPR really does focus on risk and do a risk-based approach, it's on the right footing.
Yeah. Let me ask you one question on this. Thank you for explaining this so brilliantly, Daniel. The question is the following. I think talking about use, harm, and risk, is a lot more difficult when you're thinking about the future. I mean, one of the developments of the last 40 years, I think, and quite clearly again now, is that that it's quite visible that we don't really know what's going to happen with personal data in a year or in 5 years. So we see this now with this whole artificial intelligence debate. But also when it comes to my home address, it might be that this is perfectly fine today because I don't see any reason why this should be sensitive. But if I don't know if I'm becoming a judge or a politician or something in a heated debate in 3 years, or if the regime changes and the political beliefs in my country change completely in a year, and nobody is expecting this today, then use, harm, and risk look very different from how they look today. And my question therefore would be whether this concept doesn't have as an unwritten basis at least two other concepts as a precondition. The first one would be the one of limiting the data collection wherever possible. So don't process data. So data limitation principle. And the other one would be the purpose binding principle. So having a legal basis for purpose A means that you should not use it for another not compatible purpose. And my question now is whether you would agree that those two principles are the fundament for your argument, and your argument is based on those.
So I would answer partially yes, partially no.
Mm-hmm.
So yes, I do think like limiting collection is important. But ultimately, I think that a lot of information is going to get collected, and I think that we also must think a lot about limiting use. And obviously, we're going to be constrained by the fact that we can only see so far into the future. And none of us have the best crystal ball, and the future can be unexpected and challenging. I think we try our best to anticipate the future, but I think that ultimately, limiting collection is a great thing, but it ultimately is. There still is going to be a ridiculous amount of data collected, just practically. It's just the way life is these days. And so I think that the idea that we're just going to stop, or we could just kind of put the halt on most data collection is just not going to be, I think, feasible. But regulating use, I think, is, and we do it in other contexts. So I recommend some very strong guardrails on how far information can be used, and one of those is the purpose specification principle. The idea that, hey, you can't take data collected for one purpose and then start using it for another purpose without consent. And I love that principle. I think the secondary use principle is incredibly important, and really does prevent information use from getting out of control. On the other hand, we have to deal with the consent part, the subject of the other paper I wrote, because it's very easy then to get consent for a lot of secondary uses that then would ultimately undermine things. So we need to also think about consent as well, because that principle does say if you get consent for another use, then it's okay. So that opens up the door to some more problems. So I kind of liken this to the following, that when I go to the supermarket, I don't have time to research the safety of each farm for when I'm buying milk. I just buy milk. I just buy meat. I just buy whatever, and I buy these products, and I just know that, hey, they're going to be safe. That someone has looked over this. There are regulations, that someone understands what's safe and not safe, and ultimately that's under control. And I don't have to become an expert on food safety. I don't have to research each individual brand to figure out, is it safe or not. Now, certainly I need to go in with I have some choices as a consumer. I would know, hey, some foods are less healthy than other foods, and I have choices, and I might, choose, fattening, unhealthy foods. But generally, I at least know there's a backstop, that like my food is not just I'm going to eat it and die. And the same thing with cars. I don't have to become an expert on the mechanics of a car. I buy a car and I know that, the car is going to have a minimum level of safety. Now, there are different cars that have more safety than others, and I could certainly look at that. But generally, there are just a lot of decisions about cars and the making of cars that I don't have to worry about, and that are regulated. So I think that that's really important. That consumers still can have choices, and there still can be freedom to share data, but there needs to be a lot more restrictions on potentially harmful uses. And I think that's the only way to plausibly do it, because people don't have the time to learn what they would need to learn to make the risk calculation to share their data. I can't. So if the company says, okay, we want your data, should I buy like a home assistant device, or should I buy a smart doorbell with a doorbell camera? There's a lot of things that, and I study this, and I would say, I don't know. How do I know the answer? Well, what are the future uses going to be? How is it going to be used? What could possibly be done with it? So I need to know all the potential future uses. If algorithms are going to be used to do anything with the data, I need to know what the algorithms say. But that's not even good enough. The logic of the algorithms is not enough. I need to know how, especially with machine learning algorithms, how they're trained. So to really understand the algorithm, I need to know all the data being fed into that. But then that would violate everybody else's privacy. But show me all that data, and also I need to know it in real time, because the algorithms are going to evolve and change. So if you tell me what it does today, doesn't mean that it's not what it does tomorrow. So tell me what it. I need the thing kind of ongoing, and I also need some computer scientists to help me understand what's going on. So I just can't. You can't just dump the data in my lap. I need to know that. So teach me how it's running. Oh, and really, to understand how well an organization protects privacy, I kind of need to know, well, do you have a good privacy officer? I want to interview the privacy officer to really get a sense of how good they are. What are their vendor agreements like? Because so much data goes to vendors, so I want to see their vendor agreements. I'd like to review all of those, please. There could be hundreds or thousands. And security. If you just tell me you have good security, well, I don't want to take your word for it. I want a security analysis of your security to make sure it's up to the levels that I'm willing to accept those risks. So you got to tell me that. Oh, do you have training? I mean, what good is policies and programs if you don't have privacy training? People need to know what they're supposed to do. So I need to see, not just do you have training, but how good is it? Because a lot of times, that's one thing I do with a different hat I wear. I have a company providing training, and there's, you can, just throw information at people, or you could really try to teach them something. So I need to see the training. And these things are ongoing. So I'm going to need, how good are your risk assessments? And I want to see your data protection impact assessments, and so on. So by the time I look at all this information, it's going to take me weeks to actually get my head around, how good what kind of risk I'm facing just with this one product and one company. Then there's all the other products the company might make. Then there's all the other companies out there, and all the myriad of decisions I'm making every day about my personal data. Oh, and on top of that, everything I just did for this one, it's because things are static. I have to keep doing. It's an evolving process. So, in a few months, it might be totally different. So I got to do it again. The bottom line is, this is impossible. So I can just get a kind of a vague sense based on very vague statements or promises about what kind of privacy I might have. But it's so minimal and so meaningless that it's not going to help me do what I need to do, which is, I want to prevent bad things from happening to me with my data. I want to be able to assess the risk of negative consequences to me from the use of my data. And right now, under the system, I can't really do that as a consumer. And as a result, you don't have effective protection if you can't really make these decisions. But the laws are kind of heaping all these decisions on the consumer as if the consumer's going to be able to make those decisions. I just want to know sometimes, look, if I go into the store, I buy my milk and it's not going to kill me. That someone has looked at these risks and it has constrained things to a point that, there's general safety. I mean, you can't do it perfectly, but I think for most consumers that, it's just the only practical way to address it.
Yeah. Let me just make a comment here. I mean, this risk-based issue is very much in the core of another piece of European legislation that is under debate at the moment, which is about the AI Act, right? And the very fundamental idea of the AI Act, as proposed by the Commission, is exactly that it should be the legislator, it should be finally the Commission deciding whether your milk, meaning the algorithm, is risky, and if so, how risky it is. And the intensity of regulation very much depends on how risky the legislator believes something might be. However, just very briefly, I would like to rephrase my argument, which is that also for a society, it's very and the legislator, it's very, very difficult to foresee what's going to be risky in 2 months or 2 years or 20 years. And there's a fundamental issue here in this risk-based approach. But I very much agree with your point on the limits of the individual and how the individual might or might not foresee these things, which leads me to the other article, which I find very, very interesting. And the main argument here, which is the argument, at least in my reading, that you're telling us that that the informed consent concept, as we see it in European legislation, but also in other areas of the world, is some kind of a myth or a fiction, or however you might like to call it here. Actually, it doesn't really work, because there are two different concepts on how this should look like. One of them is the European one, explicit, and people need to do something. One of them is the US approach, which is if people don't actively tell the other side that they don't agree, they agree. And your argument is that both concepts don't work, and that we need something something new here, which is this concept of murky consent that I haven't read about before. Could you kindly perhaps briefly elaborate about the concept? And then the second question would be, how should this make its way into the legislation? So what would be the next step then to make from a law professor's point of view on how to convince legislators that this is something that we need?
Sure. So the impetus for the paper, the first step, is that consent doesn't work. And this argument has many parts. So the problem with consent is that for a lot of the things we've already discussed, the individual can't really know what's going on. I can't really understand the risks. So I even if I see a privacy policy, I mean, most people don't even read the privacy policy, but even when I read a privacy policy, I'm still not informed. I still really don't know what I need to know to actually make a meaningful decision. And just some company saying like, "Oh, we love your privacy," and "Oh, we don't share your data, and we protect it with reasonable security." I mean, all that's totally meaningless. I mean, that really doesn't help me assess the risk of should I share my data or shouldn't I share my data. And so I think that even when consent is, quote, informed, even under the express consent of the GDPR, that's just people making some affirmative thing to say they consent. So you put a button on it. So that's what happened with cookies. So, okay, let's just put a button. You go to a website, and now something pops up in your face and says, please consent, accept these cookies. Now, couple things about first of all, the U.S. approach, I think, is terribly flawed. The idea that under some laws in the U.S. that if you don't do anything, if you don't opt out, that you've consented, I think is bogus. I mean, it's totally a fiction. We know that most people aren't consenting; they just aren't doing anything. Inaction does not mean consent, so it's a total lie. But the EU, the idea that all you need to do is click something, so I consent to these cookies. Well, and one thing that I'll click accept all the time to these cookie banners. And the reason I click accept is because the alternative is to get to another screen where I'm asked about like every single type of cookie known to humankind. Uh, like here are 50 cookies, and I can flip the things over and do all the stuff with the cookies. And I'm thinking, I just want to read this article. The last thing I want to do is try to figure out, what I want to do with all these cookies and deal with this. I just like make this banner go away so I can get on with my life. I really don't want to focus on it. I think for a lot of people, they click accept because it's just make it go away. But that's even worse than the US approach, where people just are assumed to, have consented to cookies because they didn't opt out of them. Because now it looks more legitimate, right? I've clicked the accept button. It looks like I'm consenting to cookies. It's blessed with my consent. But nevertheless, actually, my indication of that is like, I just want it to go away. I'm not really consenting. I'm just clicking a button so I can move on. And we see this a lot now in e-commerce, where here are the terms, click accept. Here this, click accept. And it's this meaningless gesture. It's not really informing people. It's not real consent. It's just creating the illusion of consent. And the problem with consent is that it confers legitimacy and power, and it confers a lot of legitimacy and power. The scholar Heidi Hurd said that consent works a kind of magic. And it works this magic because it turns things that otherwise would be illegal or immoral into something that's okay. So, I can, if I knocked you to the ground and started wrestling with you, that would be a battery. It would be a crime, or it would be an attack. But if you consent to that, well, now we're just wrestling. We're just engaged in sport. And so many things in the law that would otherwise be, disallowed are fine with consent. So consent confers this magic, right? It turns what's immoral and illegal into something that's okay. And generally in the law, consent is it's a kind of binary, right? You either have consent or you don't have consent. If you get consent, then you get all this power. And I think that there's a greater power and a problematic power when the consent is largely fictional. And so consent is fictional when, certainly in the US, when it's opt out and inaction. It certainly is not consent. But it's also fictional under the GDPR, because I don't think people can be fully informed for the reasons I've said earlier, just too much information, too hard to be informed. I don't think that, that it doesn't scale. There's too many transactions for me to actually really, learn much about. And then there's also a lot of instances where, there's a lot of manipulation going on. So, even if I do learn something about it, that there's often, I'm often manipulated and not, misled in certain ways. And on top of that, there are problems just generally with people having certain, cognitive limitations in how much they can process data. Just general human, cognition limitations that make it really hard to do this at the level that is required to really, exercise consent in a meaningful way. I mean, it's just too many transactions and too many instances to actually do consent. And I mean, the GDPR says, and it's almost laughable. It says, every time there's a new use of data, you need to get a new consent. And every instance. So we're going to go and how many consents are people going to be asked to do? Constantly being pinged to consent to this, consent to that, consent to this, consent to that. And after a while, I think a lot of people go, look, I'm getting consent fatigue. Like, how many times are you going to ask me to consent? Not only the 1,000 companies that are gathering my data and using my data, but then like every new use of the data, every change in the policy of how it might be, stored or protected and so on, we're going to have to get new consent. It's overwhelming. Like, I mean, gosh, I don't have time. The cookie banners are annoying enough. And now I'm going to have to do all this all throughout the year, constantly, hundreds of these for each company, and then multiply that by thousands of companies. Just, it's just impractical to figure out how this is actually going to work. So I don't think it's a workable way to do consent until we create this fiction that somehow there's consent if you just click a button or whatever. We rely, and we kind of ignore, the law just ignores the problems. That is the consent really meaningful? Is it actually consent in any kind of plausible sense, or is it just a show? Is it theater? And I think a lot of times this is just theater, just like, okay, get someone to click a button, get someone to do whatever. A lot of times you get the terms of service to a website, right? And imagine if you had to read the whole thing, right? It's almost, who would read like 50 pages worth of legalese, right? So but luckily you can scroll you can just click the button before you even read it. So they even set it up so like you can say yes without actually reading anything about it. So, but imagine if they forced you to read it. So some of the, we'll make you have to scroll all the way to the bottom, and that's annoying. But then people scroll really fast. But hey, we could tell actually how fast they scroll. So what if we limited it to, okay, it takes an average person, could be like, an hour or 30 minutes to read through all this. So why don't we not allow them to proceed further on the site and block them out for an hour while they actually read it? And, my gosh, that would be absurd, right? We'd never be able to surf the internet if that's the case, if we really forced that. So we don't. We just create this fiction. Just click the button, and then somehow that means you really consent, even though we know you didn't really read anything that you're supposed to read. And even if you read it, there's no negotiating on it. So here are the terms, and then I would say, well, I don't kind of like this one. Well, I don't have a choice. I kind of like, either I say yes or I say no, and that's it. So that gives rise to my intervention. How do we fix consent? Because there's this dilemma. I mean, you could just get rid of consent entirely, but I think that's a problem because I think despite the fact that people make bad choices and that people's choices are manipulated, I think that it's still valuable for people to have some degree of participation in this process. That if it's totally, the government telling, these are the only uses, and this is how it's going to be, and this is what you can and can't consent to, and so on. I think it gets too controlling. I'm not sure we want that level or that degree of total government control over all data uses. I think that's too much. So we need some space for consent, even though it's a fiction. And I think it's a necessary fiction. I don't think we can abandon consent totally. So how do we do it? And that's where I come up with the concept of murky consent. And the idea of murky consent is it goes back to the Heidi Herd idea of consent and magic. And the idea of murky consent is, what if we had consent without the magic? What if we had a consent instead of the binary of, no consent or you consent and then there's all this power and legitimacy behind what you do? What if we have murky consent, which is recognizing that consent is a fiction, recognizing consent is fraught with all these difficulties and is very murky, right? And if we strip the legitimacy from the consent, if we strip the power from the consent, that consent gives you a limited amount of power, not this dramatic amount of power. It gives you a little bit of power. Then we can put a lot of guardrails on what can be done with consent to highly restrict the ability to use the information with consent. So you can use it a little bit, but you can't use it to harm people. And so ultimately in the paper, I lay out a bunch of rules about these are the things that you must be avoided. This is what we must do. Use information, only in the best interests of the person involved with consent, and so on and so forth. There are things that we can restrict without completely taking away consent, but that consent now doesn't have the power that it normally does, and it's appropriate for what it is, which is a fiction, a necessary one, but if it doesn't have that same degree of power and legitimacy, it can't do the same kind of harm, or be the same kind of loophole to allow all sorts of problematic and harmful uses because of some fictionalized consent. So that's the idea behind the paper, is try to break through this trade-off that we have right now with consent, which is a kind of all or nothing trade-off, to make something that is in the middle, that would address the problem. Because I think that either direction, all or nothing, is a loss. You have consent as it is now. It gives way too much power that's unwarranted, and becomes a terrible loophole for a lot of privacy laws. You get rid of consent totally, and then you get into this very difficult thing of how are you going to have the government define every single use, and figure this all out to a way too detailed degree. So this kind of operates in the middle with a test somewhat similar to some parts of the GDPR, which talk about you can use data, but you have to be careful about creating risks, and so on. So I think there are, and I think that's good, but I think there also needs to be other limitations, like use data, I think, only in the best interest of individuals when we're dealing with consent. So I think when we're in that situation, we need to have extra respect for the fact that if I consent to something, we need to make sure that I'm not duped into consenting to things that could harm me, that are not in my own interest. So I think it's fine to say, look, on if the consent's a fiction, and maybe I'm not fully informed, but if we make sure that my saying yes, even if fictional, is at least saying yes to something that is not, it's going to be in my interest, that someone's looking out for my interests, that's much, much better than the current system, where that if it's not there, that means they can just use data for their own interests, or for others' interests, or even in ways that could be to my detriment. And somehow I've consented to that. I kind of think, no. I mean, I think if the law prevents that, that makes it safer for me to consent, knowing that, hey, I when I say yes, I say yes just under certain conditions that keep me safe.
Yeah, let me just add one remark here, because I think we are coming back to the very beginning of this conversation, because also this idea of the magic within consent is a rather old tradition. And this one here even goes back to Roman law. There's a Roman proverb, volenti non fit injuria. So who gives consent, there is no harm then if you give consent. And the world 2000 years ago was a little bit less complex than it might be today. And therefore, just like with the idea of informational self-determination, I think this is also something where one needs to argue, and one needs to think about in how far these ideas, 50 years old in the case of informational self-determination, 2000 years old in the case of consent as a magical tool, might need some rethinking. And probably it's the IT lawyers bringing this on the agenda because of the close relation we have with the technological development. Last question, therefore, Daniel, I just asked it before, but I didn't ask it precisely enough. What do you think that we should do as legal scholars now? Is our role to write articles and to hope that the legislator is, or somebody in a political body is reading this and is convinced about this, and that the upcoming new version of GDPR will magically have all these thoughts incorporated? Or how should we as academics deal with this? It's a very tricky question. I'm sorry, but it's a very important one, I think.
Well, politics is not my expertise, and there are, my thought is, like, I hope that policymakers will read scholarship, and as a academic, I try to get my work read by as many folks as possible, not just other academics, but also practitioners and regulators. So certainly, I want to. And luckily I'm able to interact with a lot of them, and know some of them, and that helps, because then I can share with them my work, and I hope that they will find my work to be useful and practical. As an academic, I really try to write work that is practical, and not just that. I love theory, and theory really informs my work, but I also think it's very important that my work be practical and usable. But that said, I think that, there's so much I can do as an academic. My expertise is thinking through privacy law, and taking, my years of study and reading and interacting with people and learning to come up with what I think are the best solutions and the best arguments that I can make and the best analysis I can do. There are others who have a much better expertise in how to influence the legislative process, or how to have an influence on judges, how to get these ideas actually into the law. I'm not an expert on even U.S. politics, let alone on EU politics. There are others who really understand how to get stuff done and how to get ideas into the law. And so I kind of think the answer is that academics can't do it alone. My lane is I'm going to think through ideas. I'm going to try to get them out there. But ultimately, it does take another group of folks, advocates and others, that really understand how the political process works, understand how to get those ideas and sell them into the process, and kind of inject them into those ideas in. And those people are key, because they understand the people involved. They know the mechanisms and the effective ways to get the ideas to the right people, to be considered. And so I think they play a very key role. So I write in the hopes that they will take that up and they will like these ideas, and then they will help kind of get them to the right places, because it's just something that I don't, it's just not something I'm particularly expert at or good. I wouldn't, I know only a little bit about the EU. I'm very humble about the amount I understand about the GDPR and the EU. I'm an outsider. I'm looking at this from a background primarily in U.S. privacy law. I'm a great fan of what I see in the EU. I'm fascinated by it. I love learning about it, but ultimately, I'm still a novice on it, and the politics is very complicated. And one thing I did learn enough that EU politics is, it's not a monolith. There's many different perspectives, many different strands to this. It's not all unified, and there are different things that are pushing and pulling for the future of the GDPR, and different ideas that are coming into the GDPR that are, they're trying to get a harmonization, but there's always, they're not all the same, and there's conflict. So understanding all that, and then figuring out, well, how best to navigate that terrain is incredibly tricky, and something that I wouldn't be able to even begin to fathom how to do.
So what I'm completely sure about is that this is a very, very important contribution to the policy debate and the political debate that we are having here in Europe at the moment. Thank you so much for your time, Daniel, and thank you so much again for sharing your so important and fundamental thoughts with us in these two articles. If you should be a policymaker, or if you should be a lawyer, or just someone interested in data protection, please believe me, you need to read both of the pieces. It's both of them about 50 pages, groundbreaking, eye-opening, fundamentally important. Please take the time and read them. Daniel, thank you for your time. I'm very much looking forward to talking to you in the future, if I may, about further developments here in Europe and outside Europe. Thank you so much to all of you. Stay healthy, stay connected, and stay interested. See you soon, hopefully. Bye-bye.